Indrasani may kindly read what has happened in the country. These non-vote banking people are not ready or not even having power to bargain. That is why since decades you bracketed me as a Brahmin, as a provider community, then denying my basic rights. Now there is not a welfare legislation, but it's a historic legislation. It's a revolutionary legislation by touching the tears of that poor people. That is what, my lord, first I am saying that I am not against your compartment. And at least what you are arguing, what is your fundamental right where it is denied. If someone touched a 54 or 5 or 54 or 5, nothing happened. And something filed, my lords, repeatedly, not on a post office. We have first to repetition, whether it is followed the guidelines of my lords how to violate bill. So, Tolstoy Act passed 14 2 days repetition filed without argument. So what happened, my lord? We must be very cautious because of section of the people from the protected category misunderstood. Misguided them that your rights have been taken away. For example, my lord, last day when I asked about I said that Viking temple, somebody asked me, you are against it. So busy. What to say? So this is what happened with this repetition. So it has to be dealt with very strong kinds of law, my lords, because it is affecting our country, and that law can be done fully by laws. See what is their prayer? Did somebody touch their rights? No. But by touching the tears of the poor Brahmin, Rishabhur Brahmin, I am saying, Rishabhur Vaishyan, Rishabhur Kshatriyan, Rishabhur our best conductor, hotel employee, as land aging submitted. So just to touch their tears, now what is your problem? Now you want to include, come, then you leave that compartment. This is what my lords, one area. Now, my lords, I said the objects and reasons, my lord. Then, my lords, we'll see page 2 and 3, how this bill passed. And, my lords, page 4. My lords, my respectful submission, page 4, top. According to, my lords, Keshavananda Bharati, and the subsequent judgments, the foundation, the pillars of the basic structure is democratic, economic. Economics derives from the preamble of the Constitution itself. And this is completely followed, totally followed in passing this amendment. And this 15.6 or 16.6 is nothing to do with other articles. My lord, may kindly note this point. It is not at all inconsistent with any of the articles of the Constitution of India. So therefore, if it is, my lord, agreeing that if it is passed without any problem or without any illegality, considered by other side, my lord, then my respectful submission. Now you are touching, you are coming to a democratically passed bill or act. So who is trying to play fraud on Constitution? Not by us, not by this act. So you want? We told you 15 minutes. Yes, my lord. I am just completing. I am just completing. Because I am EWS. No, you want take 5 more minutes. Yes. Yeah. Then, my lords, Indira Sani. Then economic criteria can also be considered. Indira Sani, page 4 and 5, my lords. Then Ashok Kumar Thakur, my lords. Paragraph I just indicated there. Page 6 and 7. Nagaraj. Then, my lords, page 7. 8.8. Roman 8, my lords. Middle of the page, my lords. Yes. The submission of the petition exclusion is as we are already included or inclusion in the EWS, it is illegal, like SC cannot take benefit of ST, so and so, so and so. And my lords, then one important submission is page 7, my lords. Now, kindly have the Constitution for a second. Yes, please. My lords, I am saying what I am going to say, my lords. 31C is my fundamental right. May I read 31C, my lords, with great respect to my lords' law. Saving of laws, giving effect to certain directive principles, notwithstanding anything contained in Article 13. No law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred, etc. Now, my lord, may directly come to 39. So, 39, B and C especially, my lords, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. That the operation of the economic system does not the concentration of wealth and means of production of to the common detriment. So, my lords, now see how it is interpreted, this very relation of 31C and 39 is described in Keshavananda. That is what pages 7 to 9, my lords. Now, my lords, I am answering to my lord Chief Justice's question that, my lord, again I am repeating to substantiate this table that none touched your rights, none taken away your rights. It's a special compartment with the available data, with the study report. There was no adequate representation. The government appointed a commission in 2001 or 2, and that is submitted in 2010. That commission saying that after consulting each and every state government, saying that these particular people also has to have some consideration. So now my lord Chief Justice asked, see how you can perpetually poor or the untouchability. If I am a C, that will continue as a C. So therefore, tomorrow if I become a property, even then I am a C. Very well. My lords, that's why my respectful submission, my lords. T1 onwards, in Indira Sani itself, as I indicated, my lord, that perpetual poverty is there. That is why state of Kerala, well, kindly page 2. That's why state of Kerala appointed a commission before this act. The Kerala State Commission for Economically Backward Classes among Forward Committee is a statutory commission constituted by the Government of Kerala under the Kerala State Commission for Economically Backward Classes among Forward Committees Act 1. So, under Section 3 of the Act, the Government of Kerala has to constitute the commission with a retired judge of the Honourable Supreme Court or High Court as chairperson with the 2 members belonging to Forward Committee having special knowledge in matters relating to forward funds. So, my lord, my respectful submission, it is not first time. It is some other states also it's there. And therefore, what is my submission is this, my lords. The question is, my lord's question, my lord Chief Justice's question. It is not perpetually you are not poor. But I remember, my lord, I recollect my lord Justice Bhatt's question. You are poor. Your father is poor. Your grandfather is poor. So, my lord, this three is not. I'm not Indian citizen at all. Therefore, my lord, what they are having the rights, I want to send my children also to the school. My children also has to get some food, dress. So, is confined to the point. And my lord, my last submission is my lord started table. Yes. My lord, page 11, page 10, my lord, is very important. My lord is this first one. Yeah, page 10, my lord. What is the result of this particular law is this? We are going to read an area which is a casteless society. This is the only community in India, according to me, or as per my limited knowledge, my lord. They went to the Chief Minister of Kerala and said, we don't want any caste-based reservation. We need that economic criteria reservation. My lord, this is the beauty of this particular act, my lord. We are reaching. This is what the foundation of the debates Assembly, my lord. My case of the Constitution, my lord. After the effect of the amendment and increase the seats are reserved, then there will be equality at the level where it was prior to the amendment and post the amendment. Yes, and they are actually benefited in addition. But yeah, may have happened in a particular fact situation, so therefore we'll note that. Any other submission, Mr. Biju? My lords, now come to page 14. My lords, page 15. And I have already taken 10 minutes. Yes, I finished, my lord. Therefore, yes. My lords, page 14 to 16 says that government also decided to increase the seats and appointments and thereof. Yes. And this is what my submission, my lords. Ultimately, my lords, again, I may submit that, my lords, this is no case so affected their fundamental rights. Writ to jurisdiction 32, I request, my lords, with utmost respect, my lords, I filed so many petitions, Devada's case, Credo case, so many. I was getting a call from the registry that this has not been followed, this guidelines has not been followed. I don't know how this T5 writ petition numbered, what is their prayer, etc. Mr. Biju, argue on merits, correct? No, my lord, not followed the guidelines, that's it, my lord. So therefore, my lord, ultimately my submission is that, my lords, the Sindhu Commission adequate representation and this poor people, and accordingly they have to get some kind of accommodation according to the constitution and fundamental rights. Their rights may be protected. With utmost respect, my lord, I am grateful, my lord. Thank you. Thank you. Especially, thank you. Grateful.
Can I have only 5 minutes? Yes. Some developed something which has come to my notice, that yes. I duty bound, but I undertake to place this in e-copy format as well as the bound format. It's only 1 page. Therefore, my lord, right now not in a bound format. Because as my lord, I have indicated that the government as a sovereign is responding to the wishes and aspirations of.
My lord, I am going to another.
Oh yes. Aspirations of several, my lord, and this is what, my lord, we have tried. There are 3, my lord, 1 and 2, your lordships can ignore. It is submitted that contemporaneously with the constitutional amendment, a decision was taken in order to ensure that the seats available to the reserved category and the open category are not impacted in absolute numbers. The Department of Higher Education issued orders on 17 January 2019 to all central educational institutions to increase the intake in all branches of study to provide 10% reservation to economically weaker sections while protecting the proportionate reservations for scheduled caste, scheduled tribe and other backward classes, and also not reducing the seat availability in the general category in absolute numbers in the year 2018-19. It is submitted that as per the calculations done in this regard, in order to provide 10% reservation for the economically weaker sections without adversely impacting the proportionate representation reservations to the SC, ST and OBC categories and not reducing the seat availability for the general category in absolute numbers as compared to admission rate in 2018-19. The total increase in intake has to be increased by approximately 25% over and above the intake in 1890. It is submitted that a total of 2,14,766 additional seats were approved to be created to in the central educational institutions, and an expenditure of rupees 4,315 crore was approved to be incurred to improve the infrastructure in the higher educational institutions. This is proportionate, but saying
correspondingly, I would like you, not right now, to give the data over a period, maybe.
your lordships.
Yes, give the data about the number of scholarships available to all people. Number of scholarships. There is a scholarships portal. What I have been able to get is a very limited. What is the kind of scholarship that you give for medical, engineering, and other professional courses which are the subject of these central universities? The quantum of these per capita, scholarships, because we are looking at people, whether it's this or that doesn't matter. The poorest of the poor in all categories. Ultimately, when they get in, what is the fee that they pay? What is the aid that the government gives? Because that is an important component also of affirmative action.
But since it has fallen from your lordships, it's my duty to provide that detail. So, I very emphatically would respectfully submit that those figures and statistics would be relevant for the parliament to take a decision whether to provide for this or not.
No, you are right.
May not have any impact on the constitutionality.
No, you are right. We want to know. For instance, the National Scholarships Portal says that for a higher education, 82,000 scholarships are given throughout the country on economic basis. And there is a separate one for SC/ST. And well, I will not get a substantial amount is given, which is about 10 or 12,000 a year. Now, similarly for professional colleges or management colleges, what is the figure for even these EWS people to ultimately you're talking of the poorest of the poor, or just marginally above that?
Poorest of the poor who are otherwise not getting any reservation benefit.
No,
Number
two are getting scholarships. So I just want to know.
it has fallen from your lordships. It's our duty. We shall place.
Yes.
But that since they are getting benefit, why give them reservation?
No.
Maybe a policy issue, not a constitutional issue. That's all.
Solicitor, we are aware of what we are looking for.
No, your lordships are aware, more than aware. Even this affidavit, absent this affidavit, it would not mean that the constitutional amendment fails. And with this affidavit, it would not mean that constitutional amendment is constitutionally valid. This is to satisfy your lordship's conscience. If there is some doubt that this might have an impact on the general candidates who are otherwise meritorious. And if your lordships have any doubt that these are three silos, three separate zones, and if your lordships were to take a view that poorest of the poor, even in the first reserved category, should be shifted. The economically weaker section, 10% should go there. It would result in two things. A, double reservation in the first category. And B, it would substantially amount to amending the constitution beyond the intent of the legislature.
Very well. Thank you, sir.
And scholarship would also be merit-based as well as need-based. I'm not subject to the verification.
Sure.
And last request, the learned AG wanted to place a note. My learned AG has not placed any note, which we will file it by tomorrow. He is in the process of preparation. I'm seeking my lord's leave. It would be your lordship's question and possible answers on behalf of the government on constitution. But I'm ready.
Thank you. Yes, Mr. Navid. Yes, please. 5 minutes by the clock. So please. Yeah.
provides benefit very stable classification because we can identify or distinguish the protection of the beneficiary belonging to economically weaker section and the family belongs. And this reasonable classification has been in existence for the benefit of people since long, and it flows from Article 14. So, under that aspect, it is constitution. Now, regarding the matter of reaching the 50%, my very humble submission is that enabling provision of the Constitution cannot cut or override the mandate of a fundamental issue. The legislations constituent 15.4 and 16.4 are class legislations, and they are forbidden by Article 14. They are not in keeping with Article 14. So, to my mind, they are untenable. So, considering them for 50% reservation is untenable. So, I believe there is not peace. That's my submission. On the issue of 10% fees being awarded and not being given to 16.4 categories, they have a place of reservation. Those candidates from the reserve category have two arenas. One is their arena, reserve one, and one is the general category arena. They have two places. But the general category person has only one place. So he has been given provision in 10% of that. Now, when this OBC reservation came up, the right of the SC/ST people in the general category was also taken away in that sense. It was a constitutional bill. It is, I believe, constitutional now. That's all. Thank you. Thank you. Yes, Mr. Ravi Kumar. Mr. Ravi Kumar, who is going to follow you? Dr. Mohan Gopal, then
Mr. Mr. William, and I'll follow Ravi. And then
because I fall in the middle, the petitioners could possibly respond to me as well. Was my suggestion.
okay, very good.
Whichever way.
we all stand in one group. I see a council to address her.
Very good.
Now, in fact, after the court allotted limited number of hours, all the council appearing on this side, we have put our heads together and
Made some internal allocation.
yeah, some arrangement. So we all will fall in one group. Gopal will be in another group. Yeah,
Very good.
we'll proceed as per the consensus.
Sure. Yes.
Great. Sir, I request the court to kindly recollect the disaster of 2005 tsunami on this country. Lakhs of people perished and millions of people were uprooted. So the Indian Navy undertook an exercise to save the persons who were in trouble. So they went around the entire coastal area. In particular, we want to refer to this. Andaman and Nicobar Islands are devastated. And when the Indian Navy went to Andaman, they could find survivors. They rescued them, and they were able to do something very yeoman service was rendered by it. But when they went to Nicobar Islands, they did not find a single soul on those islands. So they declared that the Nicobaris have perished. It was a very dwindling population. So they declared. But again, they continued this search. And when 4 or 5 days when they went to Nicobar Island, to their pleasant surprise, they discovered not a single Nicobari was touched by tsunami. Then inquiries were made. Researchers came to find out how this miracle could happen. Then it so happened, the tribes of Nicobar, they live in such perfect harmony with nature. They could read the
minds of the flora, fauna on Nicobar Islands. And when the monkeys started climbing up the hill, all of them climbed up and sat on a very high tree or took shelter somewhere on top of the mountain. Not a single Nicobar tribesman was killed. Why I am saying this is, they are the most primitive tribes. In India, the tribes and the scheduled tribes in particular, they are essentially classified as scheduled tribes because of their habitat. They live in such far-off places, not touched by civilization. And more importantly, almost all of them, they do not belong to the main race of Caucasians to which the mainland Indians belong. Now, all these races are eliminated. Nicobaris are eliminated, and all the tribes of Assam are eliminated because they are scheduled tribes. I may just give a short this thing. I've given I've given a short note giving a sample survey of some of the tribes from their racial background. Kindly come to para 1.1 at page 3. Yes. Before I read that, may I request the court kindly permit me to show who are scheduled castes and who are scheduled tribes. The definition clause may kindly be exposed. Article 366.
That which is declared under 341 and 343.
I respectfully agree. But who are declared? What is important for us is who are the people who are so declared? Kindly come to 341. I go down to this reservation. Kindly come to Article 341 straight away.
For the purposes of this constitution in relation to each state.
Yes. Yes. 341 says the president may, with respect to any state or union territory, and where it is stated after consultation with the governor thereof, by public notification, specify the caste, kindly mark, the caste, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. So, the entire list of scheduled castes and the entire list of scheduled tribes are either castes or tribes. Whatever confusion that prevailed among the OBCs, that I will come to it later. But now consider this fact. Crux of this matter is a question posed by Honorable Mr. Justice Bhatt on the earlier occasion. What if two words are deleted from 15 and 16, namely gender and caste? Would it not affect the basic structure? If I may say so with respect, that is the crux of it. So I have given the details of the races to which the scheduled tribes belong. They are not Caucasians. Mainland Indians are all Caucasians. And all of them, what may kindly take note of it, eloquent submissions are made on a casteless society. Sir, all these tribes are casteless. Why did they stay away from the mainland? Because they did not accept the caste system. That was one of the major reasons. They are very autonomous societies. They live on their own. They never subject themselves to be subordinates or superiors to anybody. And therefore, they remained outside the society. They went to the hills, they went to the forests, and that is where they are living. All of them, they belong to this race. And briefly, I may give the names of certain races. For example, the northeast tribes, northeast belong to Mongolian race. Tribes like Khasi, Garo, Dankya, Gela, Minya, Anagamis, Cheslong, etc. And the central tribes, what is very familiar with these tribes, Gonds, Mundas, Santals, Marias, Beals, they belong to Austric race. And the South Indian tribes, like Betakurubas, Jerakurubas, Swaligas, Irulas, Udias, Iligas, Kondas, Todas, Kotas, they are from a Dravidian or Negroid or Austric racial features. So just keeping this in mind, kindly permit me to read the prohibition against discrimination under Article 15.1. Yes, sir. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. All these tribes have been eliminated from 15(6) and 16(c) only because of their race. No other factor. Are they not entitled to the benefit of anything that is done in the name of code? Can they be eliminated? Okay, that's just what was pleased to add. Can the words sex and caste be deleted in one for any program? Would it not affect the basic structure? Then I fall back upon the impact test. Please lift the veil of this provision. Put on the glasses to see who are the offending parties who are in 16(6). Are they not caste tribes? Therefore, my very respectful submission is that question of Honorable Mr. Justice Bhatt is the crux of the matter, and it is a clear indication that these two provisions have destroyed the equality code by allowing race and sex to be grounds of discrimination. Supposing a similar provision had been made saying that all positions in the Indian Navy or IAS are reserved for men, not for women, because women already have some benefits, 15(3). Would it be sustainable? Would it not offend the basic structure? If I may say so, in that permanent commission case, this Honorable Court has already declared as invalid any such elimination from being considered for permanent commission in the Indian Navy. So if that is true so far as sex is concerned, I, in my very respectful opinion, even a constitutional provision which eliminates these races, castes and tribes also hits the basic structure, alters the identity of the constitution. So both impact test and identity test are answered in the affirmative if we lift the veil of this so-called economically weaker sections to find out who are eliminated. I'll not trouble the court. Enough is said about who are EWS. But who are eliminated, that is very crucial. So I therefore very respectfully submit that this answers the test, both impact test as well as the identity test. Because the equality code is turned upside down by enabling discrimination on the basis of race, on the basis of caste, on the basis of tribes. Article 341 and 342 are sufficient to demonstrate. 341 may not be a fundamental right, but it is a basic feature of the Constitution. And Article 46, I'll be giving the list. Glad Honorable Mr. Justice, but just now inquired what are the scholarships that are given. I have in my own way compiled a list. I'll place it before you. In 5 minutes, I'll be placing. So it is not an official list, but it comprehensively enlists all the welfare measures that are taken in the country and in some states also. And I request the court to kindly mark that in not a single case are the scheduled castes, scheduled tribes eliminated. There may be special provisions for them, but in the general welfare provisions, scheduled castes, scheduled tribes are not eliminated, not disqualified. They are eligible to apply, they are eligible to compete, and they are eligible to be given admission or given appointment. It is only under 15(6) and 16(6) that they will not be entitled to either apply or compete for the post or take any such benefit under 15(6) and 16(6).
Yes, sir.
Then one of the substantial arguments in defense of the EWS quota is that SC/STs, backward classes are given for. Sorry, before I kindly permit me to show the backward classes also, they constitute a collection of castes and tribes that this court has declared in 13 judge bench decision in Indrasani. I give the paragraph. Paragraph 779, 780, 781, and 782 mechanism.
782.
780. In fact, from paragraph 7562, 779 relates to whether caste can be included, and para 781 court says you start with the castes. So castes are included, and what are now included are only castes as of now. There is no further classification which is permissible. So this may kindly be taken note of. Say that not only scheduled castes and scheduled tribes, the entire human sea of eliminated persons for benefit under 15.6 and 16.6 are nothing but races, castes, and tribes, and they could not have been eliminated or discriminated under the provision. That is the bedrock of the equality code. Then kindly come to para 1.2. This submission I have made. I have only given a graphic description as to what happened in Champakam Doreraja. Kindly come to para 1.2, page 4. Sir, 14 posts were distributed under 3 categories to 3 different communities on the basis of religion. Hindus were given 12, Muslims were given 1, Anglo-Indians and Christians were given 1. Among the Hindus, Brahmins got 2, backward Hindus got 2, Harijans got 2, non-Brahmins got 6. So this was what was the position under the GO, which was popularly called as communal GO, which was struck down in 2 landmark decisions in Venkatramana for services and Champakam Dorerajan for admissions to educational institutions. Now kindly come to the next. Statement 1.2.2. Now, what this amendment has done, it is a very, to put it simply, either applying the impact test, this is what has happened. 100 posts are divided into 5 categories. Scheduled castes, 15 posts. Scheduled tribes, 7.5 posts. Other backward classes, 27 posts. And economically weaker sections, 10. Now kindly stop for a minute before proceeding to the other 40 seats or posts. Now what are these 60 posts going to be? They are going to be distributed strictly according with the communal GO, namely 15.6 and 16.6. 15.6 and 16.6 have converted the entire policy of reservation into what earlier was known as communal GO. 40% may be available, but that by itself will not, as this Honorable Court has repeatedly said, honor the doctrine of equal opportunities. So 60% of the post to be divided was already divided in accordance with the Constitution as it stood prior to this amendment. And now the remaining 50% seats are subdivided into 10 and 40, while 10 go exclusively on the basis. So in my very respectful submission, this is hit by the law declared by this Honorable Court in a 7-judge bench decision in Champakam and Venkatramana. So for this reason also, this needs to be struck down as ultra vires Article 368. Then court may kindly recollect, till this the learned attorney general nor the other counsel who have addressed have provided as to what is the nexus between reservation and poverty. Why should reservation be given? Why not other measures?
Yes.
There appears to be some obsession that reservation is the only panacea for all ills. Poverty, hunger, starvation of steaming millions. That was what it was saying. What has that got to do for IAS posts being reserved for them? Starving million? IPS posts being reserved to them? IIM seats, IIT seats, institutes of higher learning. This is what is popularly known as reverse discrimination. Being obsessed with the concept of reservation. They want to extend reservation to everyone, whether or not that is needed. This has been held to be an unconstitutional exercise. In Ajit Singh too, Constitution bench, sorry, at para 37, kindly, I will not trouble the court with yes. This honorable court has said, page 37, para 37, bottom of the page.
Yes.
Kindly come to the bottom of the page. This is also a constitution bench. Thus, this court has to ensure that in matters relating to affirmative action by the state, the rights under Article 14 and 16 of the individuals to equality of opportunity are not affected. A reasonable balance has to be struck so that, when you mark these words, affirmative action does not lead to reverse discrimination. In another case, another constitution bench judgment, of course, it is a, I think, dissenting opinion, but the words used may kindly be appreciated. It says, such decisions should not and does not imply that any undue accent on qualifications, the administration can cut back on the larger interest of equalitarianism or may hijack the founding and fighting faith of social justice into the enemy camp of intellectual domination by an elite. The court in extreme cases has to be sentinel on the. This is what has been said. So, having said this, my very submission is the impugned amendment deserves to be struck down. Only clarifications which my learned friend, the Attorney General, made a very emphatic submission. Kindly, please. He said, scheduled caste, it is a homogeneous class. Scheduled tribes, it is a homogeneous class. Backward classes, it is again a homogeneous class. Now, with due respects to the learned attorney general. Now, this issue is already settled. So far as OBCs are concerned, Indrasani has permitted categorization. Now, on almost all the states, there is categorization. Of course, central OBC list categorization has not yet happened. But in other states, most of the states, in Karnataka, for example, we have 5 categories among the backward classes. So, categorization. So, it is not a homogeneous case. That's what I would like to emphasize. And so far as the scheduled castes are concerned, court may kindly recollect, as early as in 1965, a committee was appointed by Government of India to go into the working conditions and the problems of scheduled castes and scheduled. They recognized the fact that this is not a homogeneous group and therefore deserves to be differentially treated. That has not happened. Be that as it may, in the latest case of Devendra Singh, 2022 SCC, page 1. 2020.
The issue has been referred to.
Yes.
Devendra.
So therefore, should the issue of SC/STs being homogeneous and therefore they cannot be subdivided into poorer sections and not poorer sections, that issue, with due respect, it is a matter which is pending before the larger bench, 7 judges. Therefore, that argument may not be available. Even among held under the right to education.
Everything relies upon the Sino Commission. Sino Commission, in fact, relies upon NSSO, and NSSO makes it very clear this is not one relates to a social status or for a not a EW, not a C or for a not a backward class. That's what it's very clear. Then, my lord, my humble another submission is about the compartment theory. Lord, one of